You are absolutely wrong. And you have no name of anybody who, some vague anonymous person, you say,
It's
from my
so-
court. Are you going to interrupt all day? That's the problem, has always been that you want to control things. It's on your terms. You're the boss of your environment. You're on probation. You're supposed to be the probationer, and I'm supposed to be the supervising person, and she is too. But that's not the way you work. You want to control, and you keep interrupting. I used to get.
Welcome back to the channel and buckle up, because today's case is wild. Picture this, a probation hearing that should have been routine, but instead turns into a showdown between a defiant defendant and a no-nonsense judge. On one side, we have Brittany Sherry Sylvester, who decides to represent herself, ignore court orders, and even try to out-talk the judge. On the other side, a courtroom that refuses to bend to her chaos. She's already been warned, interrupted multiple times, and even placed in what the judge calls a timeout. But things reach a boiling point when her probation is revoked, and she's sentenced to 2 years in prison for assaulting a public servant. Along the way, we'll hear excuses about missing anger management, confusion over probation reporting, and a jaw-dropping claim that someone in the court told her charges were dropped. The tension builds with every exchange, and by the end, the judge makes it crystal clear, respect for the court is not optional. So, stay with me, we're about to break down every twist, every excuse, and every moment of this heated hearing. Trust me, you won't want to miss the ending.
So we're still working on off of this January 25 second amended motion to revoke probation, correct?
Yes, Your Honor, and my notes reflect that you had previously found count 1 true. She entered a plea of true to count 3, and you've been hearing evidence on counts 2 and 6.
Okay. On allegation 1, failing to report to the probation office in June and August and September 23, did the defendant admit to that, or was that?
You found that previously true back on December 18th of 23. That's what resulted in her being placed on the caseload that this probation officer is on, the mental health caseload.
Okay, we resolved that.
Yes, sir.
All right. Then there was number 2, failing to work faithfully at suitable employment, failing to provide verification of performing community service hours as required.
She pled true to count 3, Judge, by my notes.
When was that?
That was July 21st.
Was several years ago.
No.
Several years
No,
ago. That was
last appearance.
Oh, that's right. I'm sorry. I'm sorry. No, you're correct. I'm sorry. I apologize.
She entered a plea of not true.
Several minutes ago.
Yes, sir.
She entered a plea of not true by my notes to counts 2 and count 6.
Okay.
I don't have a reference as to anything regarding the anger management program.
Let's talk about that. Number 4, allegation, and we're picking this up on the second amended motion to revoke unadjudicated probation. The defendant, Brittany Cherie Sylvester, is present with her attorney, Mr. Grove, and the state's attorney here in cause number 21-38966. And again, the court has earlier found allegation 1 to be true back in December of 2023, failing to report, but we handled that proceeding, and I held the MTRP. I found that true and held it in abeyance for the defendant to continue working on probation. Number 4, allegation in this motion to revoke probation, second amended motion to revoke probation, states that you failed to provide verification of entering and successfully completing the anger management program as directed by the probation office. Is that true or untrue?
It's technically true. However, I did seek that program out. I actually sought 2 programs out at 2 different locations. The first one, the instructor did not show up at all. On the second time that I tried to seek out an anger management program, I was told that they were full. And so at that point, I let her know that it was court ordered. I spoke to Jennifer. with family services. And I let her know that it was court ordered and that I was needed to take that class. So what I was done was put on a caseload by the caseworker, is who I was assigned. Excuse me, I was assigned by Jennifer to a caseworker named Tatarisha is her name. And so from then on, I was on the list for the anger management class that I was supposed to take. So I should still be on the list for that because other court appointed, not court appointed, excuse me, other court, I just said the word. There were lots of other people that were on the list that were court order, excuse me, to take different classes as well as that one. So that's why there was a list.
Okay, well, from probation's standpoint, and again, everybody raise your right hand. You solemnly swear or affirm any statements you're making during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
You did, and defend. Okay, how do you respond on this one? It's because it sounds like she's working the anger management program on her own. But I know that's working through a supervision method from probation.
They send over like emails stating that they have signed up for the class and this is the date that it's supposed to start on. But also I gave her an option through Faith Tabernacles in Port Arthur. It is a free anger management classes that they offer. And if you don't have transportation, they do provide it.
And you gave her that back when?
It was
Right here, we see a classic example of a defendant trying to spin the narrative. Brittany insists she technically tried to get into anger management, but let's pause. In probation cases, effort isn't enough. You need verification. Courts don't just take your word for it. Probation requires paperwork, proof, and accountability. Notice how the officer immediately clarifies that free anger management classes were offered, even with transportation provided. That's huge, because it undercuts Brittany's entire excuse. She had options, but either didn't follow through or conveniently forgot about them. And here's the kicker, she admits she's been on the waitlist for years. That's not how anger management programs work. You don't sit on hold for years. You show up, you enroll, you complete. This is where the cracks in her story start to show. What do you think, though? Was this an honest struggle with resources or a pattern of avoiding responsibility?
What about,
28th.
what about that?
I do not recall being given that. However, I was given something else, a different printout regarding regarding finishing the what are those hours? Community service hours
Community service.
is what I was given a printout of. Basically,
Hold on, just a second.
so
Hold
when I
on.
went there,
Stand by,
okay.
stand by. Finish up, go ahead.
Okay, so when I went to community service, that I was given a paper, stating what I was to do, who I was to meet with, which was Rose Payton. I was denied that, but that's the only thing that I can recall that I was given something in writing to actually go and see about this. I do not recall being given any information regarding the anger management class. However, I do remember being given a pamphlet of some sort. However, I had already mentioned that I had already knew of a place that was doing the anger management class. So I didn't think that I was going to have an issue with basically being able to take the class. I didn't think it would take but a few weeks to complete that is what I thought. However, it's been years and I'm still on that wait list is what I'm assuming. However, I do have ability to pay for the class now. However, at that time, I was in a homeless situation, but I was looking for a suitable home and things like that. And I had gotten stolen from is what had happened. I was, my check had been stolen, so that was why I was having issues with the payment for,
What about-
for the class. However, I
Okay.
was working,
Okay.
but that job
Major
didn't
point
last.
on that one, on
Okay.
6. This number 6 states you failed to report to the probation office on or about September 14th of 2024. That's the last problem here.
That was for the judicial review. She was supposed to be here.
She's supposed to be here. And then what happened? She failed to be here.
Right. I believe she spoke with Miss Ellie stating that she would be unavailable. Last time we had came, that's what she stated.
Okay.
She also testified, I believe, that she thought the charges were dropped or something of that nature, even though they weren't. He thought they were. He
Right.
didn't need to come. I believe.
Wait. Just because she thought that, who told her that?
Someone at the court.
Who?
At Judge Stevens' court. I don't know. I guess your clerk.
Do you have a
That's who I
name?
spoke with. No,
Well, I mean,
there was 3 different clerks that I had actually spoken to.
Who
But I
told you
was
to-
told.
who
it
told
was-
you to report here in the first place? To report to the probation office? It was to the probation office for a judicial review.
Well, the last time that we were in court, in, I think, 2023,
No,
I
I'm
was
talking
in
about
court.
on
Well,
September 14th, 2024.
huh? Well, what I was getting at is a while ago, I was in court with, like in this court with just Stevens, and what I was told was that you wanted to see me back in 6 months. However, I wasn't given anything in writing, so maybe that's the judicial review that she's talked about that I was supposed to be
Okay.
here for. However, once those charges were said to me last year to be dropped around
Mhm.
August of last year, I assumed, excuse me, it could have been like June or so. I assumed that meant that I no longer needed to check in, and I did call her, but she was unavailable, so I left several messages.
Call who?
This is where things spiral. Brittany claims she thought her charges were dropped because some unnamed clerk supposedly told her so. But let's get real. The only person who can dismiss charges is a judge with an official court order. Verbal rumors don't count in the justice system. And look at how quickly the judge jumps in, because this excuse is both dangerous and flimsy. Imagine if every probationer could just say, "Oh, I thought my case was dismissed," and walk away. The system would collapse. The judge is visibly frustrated here, and you can feel it. He's not just annoyed by her excuses, he's pointing out a deeper problem: her need to control the narrative, interrupt the process, and make everything bend to her terms. This is where the audience has to ask, do you buy her story, or is this just another delay tactic? Drop your thoughts below.
My officer Mayfield.
Okay.
that
What's your response to
that
all
is who
that?
I contacted, and I did leave voicemails, but I never received a call back.
We had a judicial review set. It was actually back in May, I want to say, because this took place originally in December. And then after that, it was reset, and then it wound up being reset again, and then we were supposed to come for on the 14th of September.
Of last
And-
year.
Correct.
And then that didn't happen. Otherwise, was she reporting properly?
No,
Oh, she had absconded?
she wasn't absconded until August 30th of 24. She last reported to the office May 28th of 24. And that's when she had said, whenever I would speak with her, she told me that she was informed that her case was dismissed. And I was explaining to her that that's not the way it works. We don't have documentation, and it's only Judge Stevens that signs off on that.
Okay, so what period of time did she fail to report? No, she had already, we had already found earlier failing to report in June, August, and September of 23.
Correct.
After that,
It was June 27th of 24, July 18th of 24, July 30th of 24, and then July 31st. She was also scheduled on August 22nd, but that was the day that she was arrested on since that. 24.
okay. And you knew you had to report every month, right?
Prior to me being.
You knew you had to report every month, right?
That my charges were dropped, yes.
Who told you your charges were dropped?
There was a lady that I spoke with, one of your clerks. I contacted them and told them what my name was and asked them to look up the cause number. And I told them I was representing myself at that time. They looked it up and said that we showed that there are no charges under your name, is what she said. So what I did was I let Officer Mayfield, know that is what I was told. However, I didn't speak with her. I left it on her voicemail several times so that she would know. So at that point, she should have known that I was not purposely trying to avoid checking in, because I didn't have a problem checking in.
Well, you were.
I was always early.
Wrong. You were absolutely wrong. You were absolutely wrong. And you have no name of anybody who, some vague anonymous person, you say,
It's
from my
true,
court. Are you going to interrupt all day? That's the problem, has always been that you want to control things. It's on your terms. You're the boss of your environment. You're on probation. You're supposed to be the probationer, and I'm supposed to be the supervising person, and she is too. But that's not the way you work. You want to control, and you keep interrupting. I would be called down in second grade for that. We learned in elementary school not to interrupt. That's rude, but that's what you do.
And there it is. The judge finally snaps. He compares her constant interruptions to behavior you'd expect from a second grader. That might sound harsh, but it's accurate. Courtroom decorum isn't optional. It's a fundamental part of the legal process. When the judge says, you want to control things, it's on your terms, he's identifying the root issue. Brittany's not just failing probation requirements. She's fighting the very structure that's meant to hold her accountable. This moment is so powerful because it strips away all the excuses. Forget anger management, missed check-ins, or miscommunication with clerks. At its core, this case is about respect, or in her case, the lack of it. And when you disrespect the authority of the court, the consequences escalate quickly.
All right. Anything else, David?
I'm not trying to interrupt.
Anything else?
No,
Okay.
nothing else, Judge.
I find there is sufficient evidence supporting this first amended motion to revoke unadjudicated probation to grant it by a preponderance of the evidence or greater, as allegation 6, failing to report to the probation office on or about September 14th, 2024 for this judicial review has been proven not only by the court's knowledge, but also from probation, the probation officer. And again, introduce yourself for the record.
Dominique Mayfield.
Yes, Miss Mayfield. And how long have you been her probation officer working her case?
It was February 14th of 2024.
Okay. So it's been a year and a half anyway.
Yes, sir.
Mhm. And she was supposed to be reporting
Correct.
monthly. And during your period of time, when did she fail to report? During that period of time, from early 24 until now,
It was June 27th of 24.
is what? Was
Sir.
what?
It's an answer to your question, Judge, about dates she didn't report.
Okay. So she failed to report the month of June.
Yes, the month of July and the month of August of
August.
24.
And then we had this judicial review in September.
Correct.
Okay. What, after that, when was she arrested and put in custody?
She was arrested December 14th of 24 for this first
Okay.
week.
And have you been in custody that whole time?
No,
No, you were released.
was,
Because I have 631 days that you've served.
well, no, what I was going to say is I was picked up prior to that date. It was 2 dates in December that I was picked up.
Or,
They said I was walking on the incorrect side of
Oh,
the sidewalk or something like
okay.
that is what they said. but it was within 1 week of each other that I was picked up, and I had bailed out within like a day or so. And then I was out for 1 week, and then I was picked up on December the 18th or something like that.
All right.
So her dates is probably correct.
Okay,
But-
here's, anybody else wants to add anything? Here,
Judge is right, though. You've been in
I've been in-
for 600 days.
yeah, 631 days.
Been in custody since the second time I was
Well, we're gonna
arrested.
Take care of
mid-
this.
Judge, I've got that you have found count 6 true. You want to make any other
Yes.
findings?
No. Well, earlier, we had found true in 2023. That was in the 1 through 5.
Yes, sir.
But 6 is what I'm
Yes, sir.
more concerned about is after that hearing we had last time, I continued her on probation. And then the evidence shows that she had failed to report on several occasions here since in 23 and 24 as she was supposed to, which puts it into a impossibility of being able to supervise you when you don't show up for work, as it were. So I'm going to find that to be true, and just, I can't just say enough. This is about the 5th time I'm going to tell you, please don't interrupt. You're going to get a chance to be heard. All right, what does the state say?
State recommends 5 years, Judge.
Did you catch that? The state recommends 5 years. 5 years behind bars. That's not a small ask. It tells us just how seriously the prosecution views her repeated violations. But here's where strategy kicks in. Her defense attorney pleads for mercy, pointing out that she's already spent significant time in custody. This clash, 5 years versus mercy, is the heart of sentencing hearings. The state argues for accountability, while the defense leans on time served and personal hardship. This tug-of-war sets the stage for the judge's final decision. And honestly, this is one of those moments where the courtroom tension is at its peak. What do you think? Is 5 years justified here, or should her time served count as enough punishment?
Wow, for the first time, I've never been in trouble before at all.
All right, hold on.
It's interesting.
What do you have to say, David? And then I'll ask the defendant.
Your Honor, because she has been involved this long and has been to court this many times, I'd ask that the court show her some mercy and discharge her because she's been in custody for most of her term.
Okay, I understand. Anything you want to say, ma'am?
Yes, I would like to say I'm a very responsible person. I'm clergy. I'm also an officer of the court. I'm a new election judge for Jefferson County.
Say that again.
I'm a new election judge for Jefferson County. And so,
But you have a felony conviction, right?
well, here's the thing,
She
there was
was-
trafficking involved inside of Jefferson County Jail that I reported to the Rangers years prior. And so that's really not a safe place for me. However, everyone is now mild-mannered years later. And I had a special needs child that I do still have, but I was needing to get back to him because he was in a hostage situation with a predator who was an ex-fiance of mine. So it was a pretty.
This moment is jaw-dropping. Brittany suddenly claims she's clergy, an officer of the court, and even an election judge for the county. Now, whether or not any of that is accurate, it's a bold move. She's essentially trying to paint herself as a figure of authority and responsibility while standing in front of a judge for probation violations and assaulting a public servant. Talk about contradictions. The judge doesn't even entertain it. He immediately cuts back with, "But you have a felony conviction, right?" That's a reality check. No matter what titles she claims, her criminal record speaks louder. It's a striking contrast, self-image versus documented behavior. And that gap is exactly why the judge struggles to take her statements at face value.
serious thing that was going on years ago.
All right.
And so I was trying to get out the best way that I could to attend to him and his needs
Okay.
in
Well, you're gonna-
2022. I was put in 2021 and I did a year and 2 months. And then I was released February of 2023. And then I was picked up again September of 23 and stayed until the new year of 24.
Okay, got
And
it.
then I was
Yeah, we've got all that covered
Okay.
here. I'm going to find that there is sufficient evidence supporting the second amended motion to revoke unadjudicated to grant it by preponderance of the evidence or greater as allegation 6 is proven true, as well as prior to this, the court found allegation 1 on December 18th, 2023, failing to report as well, for which we continued the defendant on probation for. But those two bases are behind this court granting the second amended motion to revoke unadjudicated probation. Thus, your deferred or unadjudicated probation is revoked. Earlier in this case, you pleaded guilty voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here at your plea hearing to find you guilty beyond a reasonable doubt, and I now find you guilty beyond a reasonable doubt.
And here we have the breaking point. The judge revokes her probation and hands down a 2-year prison sentence. But pay close attention. He emphasizes that she'll get credit for time already served, which means she might walk free soon. This is a fascinating balance. On paper, it's a prison sentence, but in practice, much of it has already been satisfied. The judge calls it the very minimum, which tells us he showed restraint here. After all the interruptions, excuses, and failed compliance, she could have faced much worse. Instead, he gives her the baseline punishment, coupled with a pointed lesson: you can't game the system forever. This isn't just a sentence, it's a statement.
Of this third-degree felony of assault on a public servant, and you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 2 years, the very minimum. You're going to be given credit for all time you have served, which ought to satisfy this sentence when they calculate it, and you should be released.
Okay.
Okay. Anything else to add here?
No, Your Honor.
All right. Thank you. We are in recess. Thank you, David. Good luck, man. To you.
For all your time, sir.
All right, let's get ready. We have a verdict from the jury. Thank you.
Thanks.
So let's break this case down. Brittany Sylvester entered this hearing with a long list of probation violations: failure to report, skipping community service, dodging anger management, and constant interruptions in court. Despite her attempts to claim misunderstandings, clerical errors, and even self-appointed authority, the evidence was clear. She repeatedly failed to meet the obligations of probation. The state pushed for 5 years, but the judge settled on 2, crediting her time already served. In the end, this case highlights a hard truth. Respect for the court isn't optional, and excuses can only carry you so far. Now, I want to hear from you. Was the 2-year sentence fair, or should the state's 5-year recommendation have stood? Drop your thoughts in the comments. And if you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Until next time, stay tuned, stay sharp, and stay engaged.